important for you to know. Today's topics will be three different things, one of which will be subject matter regarding the response time you have in both Georgia state and superior courts and separately in federal court to respond to various types of adverse actions that are brought against your client within the context of litigation. Separately and different is under the Georgia Arbitration Act, how you go about enforcing a subpoena issued by the arbitrator that a party, particularly a non-party to the arbitration, is not complying with by either failing to produce documents or failing to show up at a hearing or at a deposition or to produce documents. And then third, several developments in the realm of attorney's fees recovery, which is the result of case law that's come out in recent times since the last litigation with fundamentals on that subject matter. So those are the three subject matters. Now, I will be off screen because we have an eminent scholar in the realm of response to adverse proceedings in state and superior court, and then separately in federal court, Ms. Winifred Farria, who will be presenting on that subject matter. I'll be asking questions after Winnie gives basic proposal. I may set up a hypothetical, she'll respond, and then we're going to dig into the rules, the statutes, the committee notes, etc., that impact the answers to the questions regarding when one must respond to an adverse motion or other pleading in these settings. So, Winnie Farria, come on up.
Hello, everyone.
So, Ms. Farria, you are a paralegal at Taylor English Duma?
Yes, I am.
And you are in litigation?
Yes, and assigned to you.
So we have numerous instances where one of our opposing parties has sent us something by one means or another to which a response is required. Would that be true?
Yes.
Okay, so I'm going to move over here so you can be more looking towards the camera.
We're in Superior Court.
And so we're going to start off talking about the Georgia Superior and State Courts. And we're going to start off with the example of a motion for summary judgment that's brought against your client and is filed on the Odyssey or Peach Court electronic filing system and is therefore served under that electronic filing system. How long does the party who gets the motion have to respond to that motion that is filed and served on the electronic filing system?
33 days.
Why is that?
Per Rule 6.2 of the Uniform Superior Court Rules, a party has to respond within 30 days after service, and Rule 2.6 specifically provides that a response is due for a paper that was either served electronically or by mail.
That would be Rule 6.2?
Rule 6.2 of the Uniform Superior Court Rules. However, O.C.G.A. 911-6E provides for 3 additional days to be added when calculating the due date for a response. That statute specifically says whenever a party has the right or is required to do some act or take some proceedings within a prescribed period after the service of a notice or other paper other than process upon him or her, and the notice or paper is served upon the party by mail or email, 3 days shall be added to the prescribed period. Now, some may feel that Rule 6.2 contradicts that rule because Uniform Superior Court Rule 6.2 provides that a response is due 30 days after service of motion. However, the Uniform Superior Court Rules' preamble states that it is not the intention, nor shall it be the effect of these rules of the Uniform Superior Court rules to conflict with the Constitution or substantive law, either per se or in individual actions, and these rules shall be so construed, and in case of conflict shall yield to substantive law. So we therefore yield to O.C.G.A. 911-6E, which provides 3 additional days to be added in calculating the response date.
Okay, so 911-6E is a statute, so it's substantive law.
Yes.
Right. Now, if you could read the entirety of Rule 6.2 and note those in attendance that we are talking about a motion for summary judgment, which presumably is supported by affidavits. What does the rule actually literally say?
Unless otherwise ordered by the judge or as provided by law, each party opposing a motion shall serve and file a response, reply memorandum, affidavits, or other responsive material no later than 30 days after service of the motion. Such response shall include or be accompanied by citations of supporting authorities, and where allegations of unstipulated facts are relied upon, supporting affidavits or citations to evidentiary materials of record.
Okay, so under that rule, it certainly sounds like you have to file all your affidavits along with your response, and that has to be done within 30 days. But we've learned under 911-6E that you have the additional 3 days.
3 days.
Which for those in the world has sometimes been referred to as the mailbox rule. I know people don't use mailboxes anymore, but the general theory there is that in the olden days, it would take some time for somebody to mail something to you and for you to actually get it.
Right.
And in the olden days, that mail had to go in the mail pursuant to rule and also pursuant to a certificate by the serving party that it was put in the mail. And so I guess the intent of the legislature was that a person who was responding would have a total of 30 days to respond after getting the motion, as opposed to after it's filed. Now, however, we're talking about summary judgment here, and Rule 6.2 certainly seems to say that all affidavits in response to a motion must be filed within 30 days of plus the 3 of the serving of the motion. However, since it's a summary judgment motion, what other alternatives or additional alternatives does a responding party have with respect to filing affidavits?
Per O.C.G.A. 911-56C, it states that, that a party can be served, an adverse party can be served prior to the day of the hearing.
With affidavits.
With affidavits.
So if you're responding to summary judgment, and let's say you failed to file anything within 33 days or to serve any response within 33 days to a motion for summary judgment in state or superior court, what can you do as a last ditch effort in order to avoid having summary judgment granted against you, assuming the party has made what would appear on its face to be a meritorious motion?
I would file an affidavit.
Okay, then that affidavit would give rise to a genuine issue of material fact as to whether judgment should be granted.
Yes.
You hope, if you can get the testimony. Okay, so what about other documents and things you have to respond to in state and superior court?
All other documents that must be filed will still fall under that 911-6E rule, which would apply to allowing 3 additional days for service.
Okay, now we have, and I noticed the camera has changed, so I'm now in the view of the camera, which I did not know. We've talked about the Uniform Superior Court rules. What about the state court rules? Are there any rules for the state court?
The state courts as a preamble says that we are to apply the Uniform Superior Court rules in their court. So whatever rules apply, the rules that apply in Superior Court also apply in state court.
Okay, now what if there are actually some rules issued by the state court?
Then we definitely need to always check the rules to be sure that there is not there's not a different rule, that the different rules, that there's a different rule in state court versus Superior Court.
Okay, the fundamental premise of litigation fundamentals with Henry Quillian is read the rules, right?
Read the rules, always read the rules.
Okay, so if you had a motion to compel served against you in the state courts of Georgia or the superior courts of Georgia, and that was supported by affidavits by the party that's seeking to compel documents from your client, when do you have to file the affidavits? When is the deadline for filing the affidavits against that motion to compel?
According to O.C.G.A. 9/11/37, that affidavit would be due within 30 days plus the 3 days after that we would be provided under 9/11/6E. And there is no fail-safe remedy to receive additional time that you would receive if it was an affidavit filed regarding a motion for summary judgment. That rule 9/11/56C that allows the affidavit to be filed up to the day of the hearing for motions for summary judgment does not apply to motions to compel.
Okay, and that's actually the day before the hearing, right?
The day before the hearing, right? Yes.
So if you should walk into the court and try to file an affidavit in response to a motion for summary judgment, the court ought to reject that affidavit. Right. But if you file it the day before, and I tell you what, I've actually, in some circumstances where I got new evidence or actually got an affidavit signed because of a witness that was hard to track down or something, I've run to the courthouse, 5 p.m. the day before a hearing to get it on file. And then, of course, you need to try to serve it on the opposing party very expeditiously so they'll know what you're using to contest their motion for summary judgment when they show up for the oral argument.
Right.
Okay, now, all's fair and good in state and superior courts of Georgia, but what about in federal court? Don't you get that mailbox rule, those extra 3 days, if you're responding to something that's received upon service through the federal ECF system?
Unfortunately, you do not.
And why is that?
In 2016, Rule 6D was amended to remove service by electronic means, providing the 3 day additional rule, 3 day additional days for service. Specifically, that rule says when a party may or must act within a specified time after being served and service is made under Rule 5B2C, which is mail, D, leaving with the clerk, or F, other means consented to, 3 days are added after the period would otherwise expire under Rule 6A. If you will circle back to Rule 5B2, there is a reference to a item E, but when it's quoted in Rule 6 of the Federal Rules of Civil Procedure, 6D, you will notice that E, which discusses electronic service, has been eliminated. So therefore, these 3 days would not be available to you to add to the calculating the dates for response under Rule 6D, because it so states that the 3 modes of service that would allow these 3 days would be if you were served via mail, leaving with the clerk, or other means consented to, but that it does not include electronic service. So if you were served electronically, which we all usually do in federal court, you will now not receive the 3 additional days, and you should be only calculating 30 days for your discovery response or your response to such pleading.
Okay, so to me, that's a little bit unfair. They changed the rules. They eliminate 1 letter and 1 comma, right? That's the
Yes.
only thing taken out. How in the world is one to know that a letter and a comma has been taken out of a federal rule that you've been relying on for years?
Always read the rules and the commentary that shows beneath the rule, because that is where I found this committee note that stated that this rule has been amended and it has eliminated electronic service that allows it eliminated 3 days to add additional time to and when calculating your response to a pleading when served via electronic service.
Okay, and what was the sort of the rationale for taking away that additional 3 days, just in general?
The rationale was that there was concerns about technology and the mail and transmission might be delayed for some times, or particular concerns that incompatible systems might make it difficult or impossible to open attachments. But with the advances in technology, that has taken care or alleviated just about all of that. And so the committee felt that there was no need anymore to allow these 3 additional days.
Okay, so generally, for those out there, the way the federal rules are, the way they come up with them is they, of course, never initially didn't exist. Committees got together and proposed the federal rules. The federal rules were adopted. And then every so often, committees on the federal rules get together, talk about whether it's wise to make changes and come up with proposals. And then ultimately the courts have to decide on whether they change the federal rules or not. But in this instance, they did decide to take that letter and that comma out, which makes the difference in the rule.
Yes.
So, so in federal court, you're often given a specific time period to respond to a given item, whether it be a motion or discovery, and that specific time period is the period you have to respond. So, of course, what that means in part is you better watch for what's coming into your mailbox, because that's going to be the day you have to start counting. Is that correct?
Yes, exactly.
Okay. And there's really not an excuse if your mailbox isn't looked at. There's not an excuse if you if it goes into a spam filter, which you certainly hope you're set up your system so that your federal court pleadings don't go into spam. And so read the rule. And in federal court, you don't have the mailbox rule as a benefit if you're responding by if you're getting it by electronic service.
Yes.
So I thank you so much. Does anybody out in the world of Taylor English, either in the room or exterior, have questions to Ms. Farria regarding these subject matters? All right, we're not seeing anybody pop up, so thank you so much.
You're welcome. My pleasure.
That was awesome.
Thank you.
All right, so we would love to be able to say that all this was totally clear in everybody's mind long before Ms. Farria started looking at this subject matter. But in fact, it wasn't, in part because of especially in state court, the conflict between substantive law, where when you see a statute that says, unless otherwise provided by law, this is the rule, you've got to worry about, well, what does law say? And then you have to figure out how to resolve conflicts between the rule, which is set by the courts, and the law, which is set by the legislature, and also potentially case law that construes the legislative law and the rules to come up with the final ruling order. So in the instance of the response time in superior and state court, I suppose the rule from Litigation Fundamentals with Henry Quillian is don't read the rule, read the statute and maybe read case law construing the statute as well. So unfortunately, that one was not straightforward or simple. Now, we found this in recent times, another totally different subject matter, but a miscellaneous one that has come to our attention in more recent times about how do you enforce a non-party subpoena issued by an arbitrator who is acting under the Georgia Arbitration Act. Now, that may seem like an out-of-the-box question, but nowadays, in many transactions, those that take place between people in Georgia where they've agreed to arbitration and haven't agreed to the Federal Arbitration Act, which, by the way, subpoenas of non-parties in the Federal Arbitration Act is the subject of an entire additional hour-long session in Litigation Fundamentals with Henry Quillian. How do you get your information that you need from a non-party in Georgia Arbitration Act matters where the arbitrator is acting under the Georgia Arbitration Act? Well, so of course, first thing you would do is you would ask the arbitrator to issue a subpoena that has what you want in it to be produced by a non-party, which could be documents or could be for that non-party to show up at a hearing or to show up potentially at a deposition if the arbitrator is willing to issue an arbitration subpoena to a deposition for that person. And let's assume the person that receives it says, well, I don't know who this arbitrator is. I don't know who the arbitration forum is. It just says XYZ Arbitration Association. This is not my problem, and I am not going to respond to this subpoena. I'm not going to give these people documents. I'm not going to show up at a hearing, and I'm not going to go to a deposition. Can the arbitrator throw that person in jail for not showing up? Anybody got a guess? The arbitrator cannot throw that person in jail at that point in time just because the arbitrator has issued a subpoena. However, we've got the Georgia Arbitration Act does have enforcement procedures for arbitrator subpoenas. I mean, basically, the legislature and the courts, frankly, favor arbitration as a means of resolving disputes. And the Georgia Arbitration Act provided for means for getting an arbitration subpoena enforced. So if you go to O.C.G.A. 9-9-4A1, it says any application to the court, it's first of all, it lays out that an application to the court may be made to enforce a subpoena. So the question would be, what court, what kind of application, who's a party to that application, and how do you get an order issued under that application? So this would be what I think would be called a miscellaneous proceeding if you were to check a box on the civil action form at a superior court. And it does in fact say that you're supposed to go to the superior court, and then it has a venue provision that says which superior court you're supposed to go to. So first of all, you've got to conjure up what your application or petition is. And it basically would be a petition or an application to enforce a subpoena issued by an arbitrator duly situated under the Georgia Arbitration Act. And under O.C.G.A. 9-9-4B, it gives you several options or mandates as to where the venue for such an application would be. And it says, venue for applications to the court shall lie, 1, in the county where the agreement, the one that has the arbitration agreement in it, provides for the arbitration hearing to be held. So presumably you could have a contract entered into in California that says that the Georgia Arbitration Act will apply. Parties have agreed to it. And that the hearing will be in Atlanta, Georgia, even between two parties in California. And let's say it says Atlanta. So then you've got to figure out, okay, so if the hearing is in Atlanta, what venue is that? Well, it could be the cab or it could be Fulton, I presume. So you would pick your venue, go to the Superior Court. The option number 2 is, or if the hearing, and I don't know when this comes up, if the hearing has already been held in the county where it was held, don't know the circumstances that you would be seeking to enforce a subpoena and where the hearing has already been held, unless, I don't know, maybe it's partway through. I don't know, not sure of the circumstance. Or 3, in the county where the party resides or does business. Now, this would be presumably the party you're seeking the information from, or if there is no county as described in paragraph 1, 2, or 3 of this subsection in any county. So that gives a wide open opportunity for you to go to some county to get the subpoena affirmed if there's no other county that's applicable. So I suppose in that instance, if you were in a rush, you would go to the county where you felt and none of the others apply. You would go to the one where you think you can get your relief the quickest and the easiest and with the least resistance from the court. So going back to O.C.G.A 9-9-4A1, it says any application to court under this part, meaning the arbitration code, part 1, shall be made to the Superior Court in the county where the venue lies, unless the application is made in a pending action, in which case it shall be made to the court hearing that action. So if you already have, let's say you started a lawsuit, the other side moved to compel arbitration under the Georgia Arbitration Act, the matter was sent to arbitration, and then the arbitrator issued a subpoena, and then the party to a non-party and the non-party didn't comply with the subpoena, then you would go back to the court where the case was already pending to get the application affirmed. And what sort of, I guess you would have to draft an order, and that order would say either the party to whom the subpoena is sent has to do X, Y, and Z in response to the subpoena, or somehow just incorporate the subpoena and say the party must fully comply with the subpoena as issued by arbitrator X regarding production of documents and appearance of person. What is not answered by this is whether, as similar to court proceedings, when you're dealing with a non-party, does the subpoena, does it require that the person be compelled to come to a deposition to which the other side has been given notice, or to a hearing, instead of just sending the party that had the subpoena requested the documents that are required in the subpoena? And I don't know the answer to that question. I do believe if a court, since you're going to have to make the party to the arbitration a party to the proceeding or the application in the court, then the party will already know that the court has issued an order saying this party has to, this other non-party has to issue, has to comply with the subpoena. So there would be notice, but does it have to be to either a deposition or a hearing? I don't know the answer to that. And as you can imagine, because it's such a finite issue, not aware of any appellate law that talks about where somebody, a non-party, has contested an arbitration subpoena or a party to a special application for enforcement of an arbitration proceeding has also tried to get up on appeal and get a ruling that the subpoena had to subpoena somebody to a deposition or to a hearing as opposed to just producing the documents that were required. But at least we have a procedure. Now, in January 2020, there was a Superior Court opinion issued that was picked up by Lexis. It is 2020 Georgia Superior Court Pleadings, Lexis 1631, which was in civil action number 2020-0007100-CV. It's known as First Investors Nevada Realty versus Benesh, BENESH. And in that case, the parties sought to enforce subpoenas that were issued by a Pennsylvania arbitrator under Pennsylvania's Arbitration Act, and then come to Georgia and enforce those subpoenas under Georgia's Uniform Interstate Deposition and Discovery Act, which is O.C.G.A. 2413-110. And the party seeking the subpoena to be enforced took the position that the Pennsylvania Arbitration Act had a provision that says an arbitrable subpoena in Pennsylvania under that act should be treated as a court proceeding. And so the party came directly to Georgia to enforce the arbitrator's subpoena without first going to the Pennsylvania court to get a commission to Georgia to have Georgia issue a subpoena to enforce against the party they wanted the documents from. And the trial court held the procedure was not correct and did not enforce the subpoena because the Georgia court felt like the Pennsylvania court ought to have to issue an order to asking the Georgia court to issue an order to enforce the subpoena in Georgia. But nevertheless, it did discuss how you get this type of action going, which is the commencement of a petition under the Georgia Arbitration Act that we just discussed. But of course, just make a note that if you're going to rely on use the full name of the statute, Georgia's Uniform Interstate Depositions and Discovery Act, you have to see whether the other state is a signator or has adopted that same uniform act in order to give the and for a Georgia court to give respect to the document coming from the other state. If it's not, you probably have to get a special commission issued by the other state's court under whatever rule they have for the Georgia court to then enforce that. So that covers the subject matter of getting documents or testimony from a non-party, which of course comes to mind, okay, if this party, if you're expecting for them to testify regarding something important at your arbitration hearing, how far in advance do you have to subpoena these people or get an arbitrator to issue a subpoena? And how are you going to know whether they show up or not? So if it's a super, super, super important witness to your arbitration and it's a non-party, then you might need to go through this whole rigmarole in order to get an actual court order to make the person show up at the arbitration hearing here in Georgia under the Georgia Arbitration Act. Otherwise, the arbitrator may say, too late, too little, you didn't get the person here. I'm not going to hear testimony any other way. They may say no affidavits, no video testimony or whatever. You might be able to get the person to talk at all, in which case you just won't have the evidence. I don't believe there's any standing rule under the Georgia Arbitration Act that says if a party that's been subpoenaed by an arbitrator doesn't show up, a person that's been subpoenaed under the Georgia Arbitration Act doesn't show up, that the arbitrator has to delay the hearing or reset the hearing or allow out of order testimony or anything like that. The arbitrator would be in control. So moving to the topic of attorney's fees, we have a brand new case that's been described in an article, and we have Junior versus Graham, which is Supreme Court of Georgia case 313 Georgia 420 870 Southeastern 2nd 378 and 22 Georgia Lexus 62 2022 Westlaw 677415. It was decided on March 8th, 2022, but it's an interesting case regarding that allows you to potentially get twice your attorney's fees or up to twice from the other side in a litigation in Georgia. And that would be under two different statutes. One would be suing the other side, whether it be on a claim or a counterclaim, seeking recovery specifically under O.C.G.A. 13611, which has as its stated grounds bad faith, the causing of unnecessary trouble and expense, or stubborn litigiousness. Be real careful with the words of that statute because they are not what they mean, just what you read them to say. Bad faith is bad faith, but stubborn litigiousness and unnecessary trouble and expense must all take place in the transaction before the lawsuit is brought, not during the course of litigation. And what you'd have to do there is win and then get your attorney's fees awarded in a verdict by the jury or by the judge if it's a bench trial. So that's all fair and good. You would prove up as part of your case in chief, your attorney's fees, hope to win. Now, what if back in time when the lawsuit started, your lawyers decided that under O.C.G.A. 91168, which is the subject matter of an entirely additional Litigation Fundamentals with Henry Quillian, your lawyer decided to make a settlement offer to the other side. Let's say that you were seeking millions of dollars, but your lawyer decided to offer to settle the case to the other side for $5. And you made it under O.C.G.A. 91168, and the other side stupidly did not accept that offer. And then you went to trial after all that time and all that work has been done, and you got a huge verdict, including all your attorney's fees against the other side. Let's say it was for $100 million. Doesn't really matter as long as it is 125% of $5. Then you already got your verdict for all your attorney's fees plus your damages. Can you then also ask the court to grant your attorney's fees that were incurred after 30 days subsequent to your $5 offer to the other side? And the answer by the Supreme Court in Junior versus Graham is yes. You can recover all your attorney's fees in the verdict by way of the judgment being entered, and you can recover all your attorney's fees incurred after that 30-day lapse in time subsequent to your offering under 91168, which would appear to be a double recovery. And whose client is going to be happy if you pull this off? Your client. So why is that? Why, when there's general rules out there that prohibit double recovery of damages, would the Supreme Court of Georgia allow such a double recovery? Maybe I ought to say a recovery twice of the same thing. Well, basically, they found that O.C.G.A. 13611 is a sanction for the bad conduct of the person that you're suing before the lawsuit started. And that O.C.G.A. 91168 is a motivating factor to try to engage settlement discussions and to avoid unnecessary litigation during the course of the litigation. And so the Georgia legislature came up with two different remedies for what would appear to be, but aren't actually the same thing. One is for a sanction required that litigation was required in the first place, and the other one is litigation continuing after it should have stopped. And so it's a fairly long holding where they go through this, because they address things such as why allow a double recovery here. And they basically say, well, the Georgia legislature came up with this statutory scheme. We're not the Georgia legislature, we're just the Supreme Court. So we're going to enforce both of them. And that allows your client to be very happy. Now, what if you took the case initially on a contingency fee basis and you presented under 13611 your entitlement to recovery of attorney's fees at 40% of the recovery, and that's how the jury calculated and was allowed to calculate your reasonable and necessary attorney's fees. So you got a verdict for your compensable damages plus 40%. And then you made the same motion after the case was over, after you succeeded in exceeding the settlement offer that had been rejected. And you made the same argument that contingency fees are reasonable, 40% is a reasonable contingency fee. So you recover another award of your attorney's fees for another 40%. So you could really get, and you would say, well, I didn't just recover compensable damages. I recovered compensable damages and attorney's fees. So now I get 40% of the total of the compensable damages plus the attorney's fees. So I don't know exactly how the math comes out, but it probably comes out really nicely if you get 40% on top of the total of the two. So think about that. As mentioned in my previous presentation regarding 91168, you do have the risk of the other side turning around and sending you a 91168 letter, which in turn could cause your client to be liable for all the attorney's fees incurred by the other side subsequent to 30 days after that offer letter if you reject it. So that is the risk you take, that your client could end up, even if they have no claims against them, ending up paying the other side's attorney's fees. And there are cases out there, at least one, where they found that $700 per hour for the other attorneys who were defending the case's attorneys would be recoverable, which could be, you might have $100,000 claim, you might have $500,000 of attorney's fees that your client, the plaintiff, could end up having to pay the defendant if they lose. So just something to think about. Now, we've started talking about procedure. We went into some procedure relating to arbitration. Now we're going to talk about and we've talked about attorney's fees recovery. Now we're going to talk about attorney's fees recovery in arbitration. And I'm not going to go entirely through that, except that generally speaking, as a rule, O.C.G.A. 13611 doesn't work in arbitration, especially if you just have an arbitration demand against a respondent and the respondent just defends. O.C.G.A. 13611 doesn't work under most rules of arbitration forums. Likewise, O.C.G.A. 91168 has been, which sometimes is referred to as the offer of judgment statute, but it's really not an offer of judgment. As in federal court, it's really an offer to settle. and under 9/11/68, that's been expressly found not to apply in arbitration proceedings because of the statutory language. But what about when you have a case where it's both been litigated and arbitrated? In this case, which we don't actually have a site yet, but when it comes out, you'll be able to find it because of the interesting names. It's called Palazzo, Palazzo space Rosa, Rosa LLC versus Dean. A party brought a lawsuit against a builder for alleged torts associated with the construction of a property. The builder brought a counterclaim against the party that was suing them, claiming trespass and some other issues. And the builder, and the claim was brought in litigation, a lawsuit. While it was in the lawsuit, the builder made a settlement offer to the plaintiff to settle for $20,000. I, the builder, will pay you, the claimant and plaintiff, $20,000 to settle this suit. That offer was not accepted. Subsequent to that, and after a good bit of discovery and litigation, the parties decided that they would agree to arbitrate the outcome instead of waiting for a jury trial. So then they arbitrated it, and the arbitrator found that the builder was entitled to a $5 judgment against the homeowner or the plaintiff, so that the outcome of the arbitration was that the builder got $5 and the plaintiff homeowner got nothing. They then went back to the court, which is still a stayed pending action, to confirm this humongous arbitration award that had been obtained by the builder. It was confirmed. Then the builder moved, saying, hey, I got a judgment against the party that I earlier offered $20,000 to. They lost entirely. And so I'm entitled to my $280,000 of attorney's fees spent in the litigation part of this dispute. And the ruling by the appellate court, in this instance, the Court of Appeals, after the trial court said, no, you can't do that, 9/11/68 doesn't work in arbitration, was that indeed, in this type of case, it is possible for the builder to recover under 9/11/68 for the litigation portion of the dispute resolution procedure, and remanded it for a ciphering out between the by the trial court as to what fees were incurred during litigation versus what fees were spent in the arbitration, and that the builder could be awarded the attorney's fees incurred in the litigation part. So, unique case, likely to be fairly unique because of the agreement in the midst of litigation to go into arbitration, but nevertheless, an indication of how the courts will rule. And I am incorrect. The builder was awarded $50, not $5. So the builder got 10 times what I thought they did against the owner, even though it was still a very small amount of money. One other note, happened to have a trial court hearing, summary judgment order, which I did not participate in. This was sent to me. This is the State Court of DeKalb County. Benita Sangrula, Sangrula versus ONBR LLC, happens to be a home purchase, build to purchase lawsuit. And the contract said that the issuance of a certificate of occupancy by the county, it was the end all and be all as to whether the house was could be deemed defective such that the buyer didn't have to buy the house. The buyer had a home inspector, and the contract actually provided for the buyer to use an inspector, it set forth the credentials of the inspector, had to be a highly credentialed inspector. The home buyer could have that inspector determine whether there are code violations and everything else. In this instance, the inspector found all sorts of code violations, but the government issued the certificate of occupancy anyway. And then the buyer did not buy the house and got sued for when the home buyer sued for breach of contract. The court held, hey, the government issued the certificate of occupancy. You got nothing to complain about. You have no claims for defective construction. First of all, you didn't buy the house, and second of all, it doesn't matter. If you agree that the government is the one to determine the outcome, even no matter how wrong the government is, you've agreed to that. The buyer said, no, wait a minute. Why was this inspection procedure in the contract? It's unconscionable for me to be to be contractually allowed to make an inspection and to tender over to the builder all the things that are wrong with the house and then still be stuck with the house. And the court basically said, tough luck, you agreed to it, which is probably exactly what the Georgia Supreme Court would say. If in the last X number of years, if you read a lot of Supreme Court decisions, you will basically find the Supreme Court says, if you agree to a contract, unless there's a statute that says something's illegal in that contract, you're stuck with what you agree to. And I'll just make a cite for your future reference. Emory Healthcare Inc. versus Van Engelen, Engelen, 362 Georgia Appeals 818. And that's specific site 821 to 822. 2022 is the year. So long and short of it is, for young lawyers and for clients, I would recommend that you pretty much strike the word unconscionable from your vocabulary, because there's so many times that a client comes in and says, I signed this, but it's unconscionable, so I don't have to do this that I'm required to do under the contract. So many times that young lawyers say, that's unconscionable. We surely ought to bring a lawsuit about this. But if you agreed to it expressly and it's not, there's no case law or statute that says this is an illegal type of agreement, you better read the contract and principally rely on what it says, because Georgia is a firm believer in contracts and will try to enforce them if it can. So that covers a lot of subject matters. I said it would be miscellaneous. It was. Any questions? Anybody online? Okay, well, thank you all for coming to Litigation Fundamentals with Henry Quillian and with Winifred Farria. Thank you so much for presenting today, Winnie, and y'all have a great day.